Yes.
Okay, students are still joining. Okay, I'll try to let you guys go as quickly as possible. So today we will not start with any other topic, but we'll finish with a breach of contract. So after the termination and last part I have already uploaded the lecture notes and the important topics in your Google Classroom. Sorry, Google, I mean Canvas. So আপনাদের ক্যানভাসে যেখানে আপনার লেকচার নোটসগুলো আপলোড করা হয় সেম জায়গায় আমি the last lecture note, which is termination breach of contract, and I have also uploaded your important topics for the midterm exams. The midterm exam is on the 11th April, so you have more than a week. So all the topics are there, the important topics, of course. Other than that, the syllabus is up to agency law. We are just this agency law and indemnity and guarantee contract বাকি আছে হোপফুলি আমাদের নেক্সট উইকের মধ্যে শেষ হয়ে যাবে ওকে let's start. Can you all see my screen?
Yes, ma'am.
Okay, yes. Okay, so we've done all the seven methods of termination. I've already mentioned what are important from this topic. This topic is itself very important for your problem as well as essay questions. So go through all the things that I've marked already. Go through the notes itself. আপনাদেরকে যা যা notes দেওয়া হয়েছে, go through all of them. ইম্পর্টেন্ট যে টপিকসগুলো তখন থেকে ডেফিনেটলি কোয়েশ্চেন্স আসবে দেখে আমি মার্ক করে দিয়েছি আর বাকি আপনাদের যে টপিকস প্রত্যেকটা লেকচার নোটস আমি দিয়েছি সবগুলোই যেই জিনিসগুলো বলেছি যে ইম্পর্টেন্ট না সেটাও স্কিম থ্রু করে পড়বেন um if the book I would say যে for your additional reading material, if you for voidable agreement, go through the book. It's a small topic. Other than that, the other topics you've already done the reading when I was not here. I would say that if for lecture notes যদি আপনারা পড়েন ভালো করে, it should be more than enough to cover for your midterm syllabus. We're doing the last method of termination. So we already know that in terms of whenever the contract creates certain legal obligations, and once that legal obligations are fulfilled, we know that the contract usually gets discharged. Parties enter into a contract, there are certain legal obligations to be fulfilled. Once those terms and conditions are fulfilled, normally the contract comes to an end. However, on the contrary, when one of the parties fails to fulfill their obligations and there is a breach, in that case, the contract is usually broken by one of the parties. As a result, the other party, the aggrieved party that we call as the suffered party, are usually discharged from all the obligations of the contract. However, once a contract is terminated, the aggrieved parties, are also entitled to receive certain remedial measures. We'll see what are those remedial measures as well. So, bridge, when the contract is being bridged, broken by one of the parties, it can be anticipatory as well as actual. What is anticipatory? As you can see in the name, anticipatory means before, preliminary. So, which means anticipatory breach of contract also occurs when a party repudiates their liability before the time of performance is due. So, if the contract is supposed to be fulfilled on a certain date, if one of the parties breaches the contract, breaks one of the terms and conditions, or is not able to fulfill the condition before the date of the performance, we call that as an anticipatory breach. So, anticipatory breach occurs when the parties repudiates their liability before the time of performance is due. Say, for example, if there's a contract between John and Jane to supply 10 tons of coffee beans, and the delivery date is 1st June. So naturally, we know that the performance will be completed on the 1st June when the last delivery will be received. The date for the delivery is 1st June. Say 10 days before, on 28th May, John informs that he will not be able to supply the goods. That is a case of anticipatory breach. So before the time of performance is due, one of the parties, repudiates their liability under the contract. Another example would be that, say, for example, I'm a seller and I have made a contract, I've made an agreement to sell my car. Okay, and the date for the delivery of the car is 1st February, and on the 31st of January, I inform the buyer that I will not be able to deliver the car, and you can take the advance that you have given. That is also a case of anticipatory breach. So যে কোনো সময় টাইম অফ পারফরমেন্স ডিউ এর আগে যদি পার্টিসরা তাদের লাইবিলিটি রেপুডিয়েট করে কন্ট্রাক্ট থেকে, সেটাকে আমরা বলি অ্যান্টিসিপেটরি ব্রিচ। ওকে, এনি কোয়েশ্চেন্স গাইস? Okay. In terms of consequences of anticipatory breach, as we know that when a contract is breached, the aggrieved party, the party who has been suffering from the breach, they can usually discharge the contract, which means that they're no longer bound by any obligations under the contract. If the seller is or has breached the contract, on the other hand, as a buyer, I will also not be liable to pay. So there's no obligation from the side of the aggrieved party, so they are discharged from all their obligation naturally because the contract has been terminated. With that, another consequences of anticipatory breach is that the aggrieved party can also immediately be awarded with legal remedies. We'll see what are the legal remedies, but legal remedies are usually damages, monetary compensations that you can avail from the party who has breached the contract. On the other hand, the more serious breach is the actual breach of contract. Why is it more serious? Because during the performance of the contract is due, or at the time when the performance of the contract is due, one of the parties fails to fulfill their obligation or refuses to perform their obligation under the contract. Let's say the same example that I used, that John was supposed to supply 10 tons of coffee beans on 1st June, and then on 1st June, John informs Jane that he will not be able to supply the goods. What is that? That is actual breach of contract. Because at the date of the performance of the contract or the date when the performance is due, the party refuses or repudiates their liability to perform. We call that as actual breach. So breach occurs, breach of contract can either be anticipatory, where the parties have failed to fulfill their obligation before the date of the performance, or actual breach occurs when during the performance of the contract or at the time when the performance of the contract is due, one of the party fails or refuses to perform. In both cases, the parties are entitled to receive remedies as well as they can discharge the contract. They can discharge themselves from all the obligation from the contract that has arisen. So we've seen that both the cases for actual breach and for anticipatory breach, the parties are entitled to receive remedies. Remedies can be, there can be different types of remedies, reliefs that you can avail because of the breach. However, আমাদের syllabus will be discussing only four types. So first, we already know that rescission. Rescission occurs when the parties cancel their contract. আমরা দেখেছি যে for termination by mutual agreement অনেক সময় পার্টিসরা মিউচুয়ালি কনসেন্ট করে কন্ট্রাক্টটা রিসাইন্ড করে ফেলে। But we're not talking about that rescission here. We're talking about where there is a breach of contract, the aggrieved party can cancel the entire contract. They have the right and they're entitled to be freed from all the obligation that arises under the contract. That is what we call as rescission. The second relief is damages. The aggrieved parties are usually entitled to receive monetary compensation for any loss or damage caused to them by the breach of contract. Whenever there's a breach, the aggrieved party is always rewarded with damages. Damages are what we call as monetary compensation for the loss or damage because of the contract. Third is specific performance. So, in certain cases, in limited number of situations, the court gives a direction for the parties to perform the contract according to the agreed terms and conditions. Remember when we were discussing the contract caused by fraud and misrepresentation, and we saw that the consequences say that the parties can set aside the agreement, as well as the court can direct the party to perform the contract according to the terms and conditions, putting back to the parties in the same position if they would have been if the contract was performed. We call that as specific performance, which is also a remedy. We call that as a discretionary remedy. Why do we say that as a discretionary remedy? Because it is on the discretion of the court if they want to award specific performance or not. So, specific performance is a discretionary remedy which is given in limited circumstances by the court where they think that it is appropriate for the parties. And it is an order which is being given where monetary compensation, which is damages, is not an adequate remedy. যেখানে কোর্টের মনে হবে যে damages is not the adequate relief for the breach of contract, the court can give a direction for specific performance where the parties are directed to perform the contract according to the terms and conditions. The last remedy is injunction. Certain, this is also a limited equitable remedy, যেটাকে আমরা বলি discretionary equitable remedy, where the court usually issues an order. It's a prohibitory order given by the court where they put certain restrictions to do something or from doing something. Say, for example, there is a building construction going on next to your house, and you go to the court and issue an order that this construction cannot be done because of the chaos that has been created, or because of the neighboring or the neighborhood has been destroyed from the noise and from the construction of the building. In that case, you can take an order from the court prohibiting the building from any construction work, or putting a restriction that the construction work can only go on from 9 to 10. That order is what we call as an injunction, which is also a remedy. So there are four types of remedy that we will be discussing. It was also part of your syllabus. Is rescission, where the parties resign, frees themselves, discharges from all their obligation, which we call as cancellation of the contract. Simply, damages is when the parties receive monetary compensation for the losses, for the damages that has caused because of the breach. Specific performance is an order from the court to put the parties perform the contract according to the terms and conditions. Basically, কন্ট্রাক্টে যে কন্ডিশনস গুলো ফুলফিল করার কথা ছিল, কোর্ট থেকে অর্ডার দেওয়া হয় যে সেই কন্ডিশনস গুলো ফুলফিল করা হবে। So parties are put back to the position where they would have been if there was no breach. Lastly, injunction. Injunction is a prohibitory order given by the court where the court directs the parties from doing something or prohibits from doing something. Okay, so these are the four remedies that are part of our syllabus and part of the discussion. এখন আমরা details discuss করব that what are these four remedies. Okay, first off, damages. Damages আমরা দেখলাম that damages are monetary compensation that the aggrieved party can claim from the other party. So there is a unique way to calculate damages. আমি ক্লাসে অলরেডি বলেছি যে এটা জাস্ট আপনাদের নলেজ জন্য জেনে রাখেন. You need to know how to calculate damages for your exams. So in terms of J damages, we're mainly discussing is compensatory damages. Compensatory damages is monetary compensation. যখন contract breach করা হয়, of course একটা party loss হয়, right? The aggrieved party কে তার যে লস হয়েছে, তার যে ক্ষতি হয়েছে, ওইটা avail করা যায় from the other party who has breached the contract. সেটাকে আমরা বলি monetary compensation as the most normal mode of relief whenever there is a breach. As I said already, that specific performance and injunction অনেক সময় দেওয়া হয়, but these are discretionary remedy by the court. So as a result, there are limited circumstances দেওয়া হয় when monetary compensation court মনে করে is not adequate. যেখানে court মনে করে যে monetary compensation will not be the right way or will not be the adequate remedy for the parties, সেক্ষেত্রে the court gives an order of injunction and or specific performance. We know that the main motto, or what we say as the main gist of the court system, is that they ensure fairness to the parties. So where they see that the most adequate remedy would be monetary compensation, সেখানে সবসময় damages is the usual reward to the parties. But যেখানে যে ক্ষেত্রে the court thinks or the parties also thinks that this is damages will not be an adequate remedy here, that is where they can also avail other equitable remedies. So let's see how can we calculate damages. So damages, as we know, that is the mm, monetary compensation. Uh, Usual rule for damages is to give the claimant or putting back the claimant in the same position if the contract was performed. So, if the parties have suffered from the breach, the parties are entitled to receive compensation for the loss and the damages that has occurred because of the contract that has been broken down. Okay, so say if you were supposed to deliver, I remember একটু আগে আমরা একটা example discuss করলাম that John was supposed to deliver 10 tons of coffee beans. সেক্ষেত্রে Jane is the suffered party. Jane will be entitled to receive damages. So সাপ্লাইটা দেওয়ার কথা ছিল, যে সাপ্লাইটা দিতে পারেনি, সেটার কারণে জেনের যে লস হয়েছে, যে ড্যামেজেস হয়েছে, that will be covered by John to Jane. John will be entitled to give damages, monetary compensate Jane for the breach of contract. That's the normal adequate, that's the normal relief or remedies that usually is being given to the aggrieved party whenever there's a breach. So when we are calculating damages, there are few factors taken into consideration when the damages are being calculated. The first rule is the aggrieved party is usually entitled to recover the compensation only the actual loss that has been suffered by them. So, actual loss is the exact amount of recovery from the party who has breached the contract by way of monetary compensation for the loss that has been suffered. So, যে actual lossটা suffer করেছে aggrieved party, সেই lossটাই সে শুধু recover করতে পারে. Okay, that's what we call as the usual calculation for damages, that the actual loss that has been suffered by the parties, they will be entitled to receive that from the party who has breached the contract. Sometimes, while calculating actual losses, the court also takes into account other circumstances, losses that are fairly and reasonably considered and are naturally arising in the usual course of things from the breach. Say if there is a delivery that was supposed to be or the performance was supposed to be due, the delivery was supposed to be on 1st February, and there's a delay for 2 months. In that case, you're paying for the extra labor for the 2 months. Your machines are being idle for 2 months, which mean depreciation charges. So what are these losses? Are they actual losses? No, they're usual losses that have arisen fairly and reasonably in the usual course of things from the bridge. সেটা আমরা বলি usual losses. The court also take into consideration all the usual losses যেটা fair and reasonable and that arises naturally in the usual course of things from the bridge. সেক্ষেত্রে the parties are entitled to receive actual losses plus the usual losses that have occurred because of the breach. There's a unique way to calculate usual losses. So, the legal principle for calculating usual losses was established from a very landmark case, which is called Hadley versus Blackstone. It's one of the most celebrated case for law of contract. So, in this case, the England and Wales High Court held that the loss should be fair and reasonably considered, and the losses should be naturally arising in the usual course of things from the breach. If the loss is not fair and reasonable, in that can it's not in usual consequences for the breach of contract, it will not be entitled to be received by the aggrieved party. So, from this particular case, usual losses were also taken into consideration. However, usual losses will only be taken into account where the losses have been fair and reasonable, that has been contemplated by both the parties, and have been made naturally in the usual course of things from the breach of contract. So losses that usually are not arise from the naturally from the breach of contract, or the losses that are not fair and reasonable to be considered that it is the consequences for the breach, that will not be taken into account when damages are being calculated. So what happened in this case was there was a delivery for a mission part. So obviously the manufacturer was waiting for the delivery. So the courier who was supposed to do the delivery uh, failed to fulfill to deliver the on the delivery date. So delivery date মধ্যে she delivery দিতে পারে না for the machine part. As a result, there has been a delay, and because of the delay, the machines of or the machines that were যে machine party জন্য wait করছিল ওটার কারণে যে the usual machines that were there, all of them were of course sitting idle. Since the factory was sitting idle for so long, they have occurred a lot of losses, incurred a lot of losses. Workersদেরকে wages দিতে হয়েছে, so because they were sitting and they were waiting for the delivery, so as a result there was a lot of losses, overhead cost as well. So the manufacturer claimed compensation for the breach of contract. When he claimed compensation, he included the compensations for wages of the workers. He included depreciation charges that was incurred because of the delayed delivery, as well as he also uh, uh, asked claimed compensation for the loss of profits. So সে ওয়েজেস এর ওয়ার্কার্স দেখেছে, সে ওয়েজেস দিয়েছে, ওইটার জন্য সে কম্পেনসেশন চেয়েছে। ডেপ্রিসিয়েশন চার্জেসের জন্য কম্পেনসেশন চেয়েছে বিকজ ব্রিচের কারণে, বিকজ অফ দ্য ডিলে his factory was sitting idle, so naturally he had to give depreciation charges. So he claimed that because of the delay the workers were sitting idle, but he had to give them wages, so as a result he claimed compensation for the wages of the worker. And of course there were he his Factory went into loss. As a result, he also claimed for a loss of profits. Now, when the court gave the judgment, the court held that he will be giving damages. He will be able to be entitled for monetary compensation. However, the when we are calculating usual losses, he will be only entitled to receive damages for the wages of the workers and the depreciation charges. He will not be able to receive any damages for the last item, which is loss of profits. So তাকে damages দেওয়া হয় for the wages of the workers and for the depreciation charges, as the court considered them as a natural consequences of the breach. So when we are calculating usual losses, the case of Hadley versus Blacksondale, the main principle from this case is that the bridge, the calculation for the damages usually should be from the natural consequences of the bridge. In this case, the damages for the wedges and the depreciation charges were allowed because they were a natural consequence to the bridge. Because of the bridge, because of the delayed delivery, the parties, of course, had to compensate for the wages of the workers as well as the depreciation charges. The court considered that as a natural consequences, as well as they were fair and reasonable to be considered. However, the last item, the loss of profit, was disallowed because it was a remote consequences. So, from this judgment, the court gave the legal principle that damages are limited to those that arises naturally from a breach, and those that are not reasonably contemplated by the parties at the time of the contract. They will not be considered as a natural consequence of the breach. It will be considered as a remote consequences. As a result, the parties are not allowed to receive any compensation for any remote consequences of the breach. So, from this case, the usual losses calculation was being introduced. It said that when we are calculating usual losses with the actual loss suffered by the parties, the usual losses will be for the things, will be for the damages which are natural consequences of the breach of contract. এখানে the loss of profits were not allowed because loss of profits can be for any other circumstances as well. আপনার বিজনেসে যদি লস করে for a whole year, that loss cannot be only for a machine part that has not been delivered. That will also include other reasons as well. That will also include other reasons for the losses as well. As a result, asking damages for the loss of profits is a remote consequences because that's not a natural consequences for the breach of contract. That's exactly what was discussed in the legal principle of this case. The England and Wales High Court held that the loss of profit cannot be reasonably be considered a consequences of the breach of contract, as it could have been fairly and reasonably contemplated by both the parties when they made this contract. For any such losses which neither have flowed naturally from the breach or in the great multitude of such cases occurring under the ordinary circumstances, nor where the special circumstances would have been a reasonable and natural consequences of a breach of contract. As a result, the loss of profits, the last item that was claimed by the claimant, was disallowed because it was considered to be not a natural consequence of the breach. So, when we are calculating damages, the actual losses as well as the usual losses are taken into consideration while calculating damages. Then, the third thing that is also being added to the damages are the legal cost. Of course আপনি যদি কোনো damages claim করেন, আপনি তো ফোন দিয়ে claim করবেন না, right? You will have to file a case. When you're filing a case, you have to pay your lawyers. There are certain legal costs that are involved for collecting the papers, for submitting the papers. So all this legal cost will also be entitled to be retrieved from the other party. So the aggrieved party is entitled to also retrieve all the legal cost of getting the order for damages. আপনি যে অর্ডারটা ড্যামেজেস পাবেন, মনিটারি কম্পেনসেশন পাবেন, এটা তো আপনি একদিনে পাবেন না। ট্রায়াল হবে, ট্রায়ালে এটা প্রমাণ হবে that there was a breach, and then প্রমাণ হবে যে these are the consequences, these will be taken into consideration when we should be taking calculation of the damage, and then তারপর you will be compensated, right? So in that case, এত দিনের যে legal cost, who will bear it? The court said that with damages, when the damages are being calculated, the aggrieved party is also entitled to retrieve all their legal costs and all other costs from the party who has breached the contract as well. Okay. Sometimes in a contract, a sum of money has already been mentioned in the terms and conditions, where the parties have already mentioned that a certain amount of compensation will be given if there is any breach. If there's any breach or the parties fail to perform their obligation, there is a penalty being given, where the court have or where the parties have already agreed that if there is a breach, in that case a certain amount of money will be given to the aggrieved party. Usually, whenever there's a penalty involved in a contract, we call that as a penalty clause. In that case, if your agreement has a penalty clause, the court will only allow that amount for or as a compensation for whenever there's a breach. The court will not allow any excessive amount that will arise from the breach of contract. Shekhetre, usual losses or all the other losses, legal costs will not be taken into consideration. If the contract has a penalty clause, in that case, the court will only allow that amount as a compensation for the way of the penalty. Say এখানে একটা এক্সাম্পল দিয়েছি that John contracts with Jane to pay $1,000 if Jane fails to pay $500 on a certain day. So যদি Jane একটা লোন এগ্রিমেন্ট অনুযায়ী তাকে $500 রিপে করতে না পারে, সেক্ষেত্রে তাদের চুক্তিতে বলা আছে that if there's any breach or the parties have not been able to pay a certain amount of money, in that case there will be a breach, and whenever there is a breach of contract, the aggrieved party, in this case is Jane, it will be entitled to recover $1,000 as a compensation from John. In that case, the court will only allow $1,000 as a compensation, nothing more, nothing else. Okay, that is the effect of penalty clause. যদি কন্ট্রাক্টে কোনো পেনাল্টি ক্লজ দেওয়া থাকে, সেক্ষেত্রে ওই অ্যামাউন্টের বাইরে কোর্ট অ্যালাউ করতে পারবে না for any other amount as a damages. Last is whenever parties find sometimes it is difficult to calculate damages. In that case, the court makes an assessment by themselves. তারা নিজেরাই assessment করে একটা reasonable amount aggrieved partyকে award হিসেবে দিয়ে থাকে for damages. Whenever it's difficult to calculate damages, the court usually gets involved and they make an assessment of losses and pass an order for damages. That's all for monetary compensation. When you're calculating damages, a few factors taken into consideration. We already saw what they are: actual losses, usual losses, cost, effective penalty cost, if there is any, or when in situations where it's difficult to calculate damages, the court usually makes an assessment of loss and pass an order for damages. Now comes the second remedy, which is called specific performance. So, specific performance are usually enforced when the damages cannot be ascertained. যেখানে damages is not an adequate relief, compensation is not an adequate relief. In that case, the court usually gives an order of specific performance. Specific performance is usually when the contract is being terminated. An order of specific performance can be enforced in order to put back the parties in the same position where they would have been if the contract was duly performed. It is an order by the court whereupon the party guilty of the breach, directing him to perform what he or she has promised under the contract. So, say for example, in the case of Bestwick versus Bestwick, 1968, a business was sold by his uncle to his nephew with a contract that said that the terms and conditions would involve regular payments would have been made by the nephew to him and his wife. Okay, so কন্ট্রাক্ট অনুযায়ী কন্ট্রাক্টের টার্ম ছিল যে নেফিউ তার আঙ্কেলকে অ্যান্ড আঙ্কেলের ওয়াইফকে রেগুলারলি একটা পেমেন্ট করবে. When the uncle died, the nephew stopped making the payments to the uncle's wife. The House of Lords granted here specific performance of a contract, not any other damages, not monetary compensation, but an order of specific performance where the nephew was forced to pay the amount of money to the uncle's wife. So, as you can see, that in situations where compensation would not have been an adequate relief to the plaintiff, যেখানে court and the aggrieved party both wants other remedies where they think that the party who is guilty of the breach should perform the contract as per they have promised in the terms and condition in an agreement. In that case, an order of specific performance is given, where the court thinks that monetary compensation is not an adequate remedy here. Also, in the case of Sky Petroleum versus VIP Petroleum 1974, when during an oil crisis in England, there was a supply of oil to the plaintiffs that was being stopped by the defendants. As a result, specific performance was given as an order because of the breach of contract, where the plaintiff, as damages, was not the adequate relief at that time. So the plaintiff was ordered, sorry, the defendant was ordered to supply the oil to the plaintiffs. That was the order given as the order of specific performance. Here, the monetary compensation would not have been an adequate remedy. As a result, the court gave an order of specific performance, allowing the supply of oil to be continued by the defendant to the plaintiff. So, as you can see, specific performance is an order, is a discretionary order, যেটাকে আমরা বলি discretionary remedy, because it is upon the discretion of the court whether they will allow specific performance or not. It's usually allowed in limited circumstances where the court finds that damages will not be an adequate remedy. The whole concept of specific performance is putting the parties, the injured parties specifically, in the position where they would have been if they have enjoyed the contract to be fully performed. The contractটা প্রথমে fully perform করা হতো without any breach. In that case, they use that option as specific performance where the parties are being forced to put back in that position where the party who has breached the contract will perform the contract fully. Usually, specific performance is given in situations আমরা যেখানে দেখলাম যে monetary compensation যেখানে adequate remedy না, সেখানে specific performance is usually given as a direction of an order. However, specific performance is not allowed in contracts of personal nature. So, যেসব contracts are being given where personal nature is being involved. Say you have a contract to paint a picture. So, in contracts where the contracts are of personal nature, in those contracts, specific performance is not allowed. Other than that, in any other sort of contracts where the contracts are not of personal nature, the contracts can be, the court can give an order of specific performance. The usual common reason for the contract to be given the order of specific performance because of the breach is where the court finds that the true amount of damage is unclear. And the general rule is always that whenever you're giving a verdict, it must be ensuring fairness to the parties. So, whenever there's a breach and the breach is not entirely a matter of money, where the true amount of damages is unclear, or where the court finds that the monetary compensation is not an adequate remedy. In that case, an order of specific performance is usually directed by the court to the aggrieved party. Say, for example, Rina offers to buy Beth's house and Beth accepts it. Okay. Now, later, Beth decides that he does not want to sell that property to Rina. In that case, since we consider houses are unique, so সেক্ষেত্রে Rina, if she's buying a house that would be costing, say, for millions, of course, in her situation, she would never be compensated with damages. For her, the damage for real compensation for her real the most ensuring fairness to her would mean that giving her compensation or relief where this particular contract is being fully performed. In situations like this, where the contract terms are unique or in limited and the consequences of the contract are also limited and unique, in those situations, usually an order of specific performance is given. Say, Khetra, of course, there will not be any other house like Beth's, right? In that case, there will not be any other property or a house that will exactly look like this. So the court will give an order of specific performance that would compel Beth to go through the sale as per the terms and conditions of the contract. So, contract অনুযায়ী, Beth was supposed to sell the house to Rina. Beth breached the contract, stating that he will not sell the house anymore to Rina. However, the court gets an order of specific performance where now the parties will be performing the contract as per the terms and conditions that was agreed upon. So, in that case, what was the terms and condition that was agreed upon? There must be a sale of the house. So, Beth would now be compelled to go through the sale. That is an order of specific performance, putting the parties back to the position where they would have been if the contract was fully performed. However, this order would only be given in situations where the contract is not of personal nature and where the court thinks appropriate because monetary compensation will not be an adequate remedy for the parties. The last damages, the last adequate remedy is what we call as injunction. So, injunction is a court order where the contracting party must do something or prohibit from doing a certain action. So, in situations where the court prohibits a contracting party from doing a certain action or it gives an order to the party from doing something, we call that as an injunction. So, injunctions are often granted when also the court thinks that monetary damages are not sufficient to remedy the given situations. So, in cases whenever there's a breach of contract, the injured party, under certain circumstances, can get an order prohibiting a party from doing something. The example let's say another example, there is a contract between uh, a contractor with a hotel, and the one of the terms and conditions says that the contractor will not be entitled to sign any other contract with any other hotels. In that case, if the contractor signs a contract with other hotels, say for example Hotel B, the Hotel A can take an order of injunction requesting him to not sign any other contract, or you're not allowed to work with any other contract with Hotel B. Say when you're working as an agent of a company, অনেক সময় আমরা যখন এজেন্সি ল পড়বো নেক্সট উইক তখন দেখবো যে the companies make them sign a contract. Contracte বলা থাকে you were in a contract with us for 3 years. In this duration of 3 years, you will not be working with any other companies. এখন যদি say that person works with any other company, সেক্ষেত্রে the company will ask for an order of injunction. So there is a breach, of course. So breacher ক্ষেত্রে will they claim for compensation? No, এখানে compensation is not an adequate remedy. একটা হোটেলের, I'm sure because of the bridge, they will not be asking for money from the contractor or from the agent for the right adequate remedy here would be asking for an injunction, stopping, prohibiting him from doing a certain action. In this case, prohibiting him from working with any other company. Because contract অনুযায়ী, when he signed the contract, the terms and condition clearly stated that he is obligated to only work with company A. He's not obligated to work with any other company for the next 3 years. এখন যদি সে next 3 years এর মধ্যে অন্য কোনো কোম্পানির সাথে কাজ করে, সেক্ষেত্রে কোম্পানি A কিসের অর্ডার নিতে পারে? Specific performance damages, না injunction. Of course injunction, because that would prohibit him from working with any other company. Say, remember that campaign that happened in the 2001 by Naomi Campbell, where she was in a deal with Victoria's Secret for 3 years, and 3 or 6 years, I don't remember. And one of the campaigns said that she cannot promote any other, I think, any other beauty products, or I think something like that. So কোনো একটা beauty products বা যে কোনো অন্য কোনো beauty products যেটা ভিক্টোরিয়া সিক্রেটের সিস্টার কনসার্ন না, তাদের সাথে নাওমি ক্যাম্পবেল কাজ করতে পারবে না. But she did. I think she did. She promoted in relation to some campaign, PETA campaign for animal rights, and then she was being sued by the company, by Victoria. So it's a very landmark case. Actually, I'm a contract law. We have studied this when we were students. So then the court gave an order of injunction that the model will not be able to work with any other company because she's on a contract with Victoria's Secret for the next 6 years. She can only promote brands where Victoria's Secret allows. Other than that, she cannot promote any other brands. So in that case, there was an order of injunction being given by the court. Similarly, when you have signed, when some so many actresses they sign, or actors they sign a contract with a production company for a span of 3 years, 6 years, and during that 6 years period, they're not allowed to work with any other production company. If they do, the অনেক সময় এরকম করে, they try to work with any other company, and then তখন court থেকে take an order of injunction prohibiting them from acting in any other movies. Say, if I'm working in a law firm, I'm obligated to only any confidential information, but যে কোনো information I'm not allowed to disclose it to any other person or to anyone else, right? Clients are confidential. এখন if I get আমার contractor বলা আছে that after I finish, if I terminate or if I have resigned, একটা period of 1 year এর মধ্যে I will not be able to work with any other law firm. যেটাকে আমরা বলি আমরা কম্পিটিং ক্লজ, এরকম ক্লজ অনেক সময় কন্ট্রাক্টে থাকে যেখানে পার্টিসরা সাইন করে যে নেক্সট 1 year পিরিয়ড আফটার দে রিজাইন দে উইল নট বি এবল টু ওয়ার্ক ইন এনি আদার কোম্পানি এজ ওয়েল, বিকজ অফ কোর্স কনফিডেন্সিয়াল ইনফরমেশন ডিসক্লোজ হয়ে যাবে এসব কারণে. সেক্ষেত্রে if I try to work in any other law firm, my previous company, my previous law firm can issue an order of injunction prohibiting me from working in any other company. So, are you all clear with injunction and specific performance? Both are adequate remedy being given where monetary compensation is not enough. Both are discretionary remedy, court discretion অনুযায়ী remedies টা দেওয়া হয়. Both are given in very limited circumstances. In one situation, usually is injunction is an order given by the court where the parties are compelled to perform as per the terms and condition that was initially agreed upon. On the other hand, the other one, injunction, is the order from the court where the contracting parties either is prohibited from doing something or they're given an order to do something in a contract. Is everyone clear? Any questions, guys? Okay, perfect. So that's pretty much all. I will not. I'll take your attendance and you can go. আজকে আমরা নতুন কোনো topic start করবো না. Next week I will start with so next week I'll start with indemnity guarantee. Hopefully একটা ক্লাসে আমাদের Sunday class will be done, and then Tuesday class we can do the revision after the problem question solving করাবো, and then next week we have your midterm exam. Okay, perfect. Take the attendance. Muhammad Al Farhat,
Present, Miss.
Nafisa Janna Zina Jabbar,
Present, miss.
Saqib Al Hassan,
Present.